The Malaysian Bar is supportive of efforts to combat the threat of terrorism. But such measures must not be at the cost of sacrificing our ideals and principles that will only stimulate the terrorists. Detention without trial is repugnant to the rule of law and has been widely repudiated as counterproductive. We would do well to recall the famous dissent in Liversidge and Anderson, where Lord Atkins said, "Amidst the clash of arms, the laws are not silent. They may be changed, but they speak the same language in war as in peace." Thus, we must reject the notion that desperate times call for desperate measures and justify a loosening of the ordinary standards of liberty and behavior for which democracies stand. Next, the amendments to the Sedition Act 1948, which were a reneging of the government's promise made in 2012 that the Act would be repealed and replaced with national harmony laws. These amendments should not be brought into force as they will further imprison thought, speech and expression. Sedition is still a poorly defined strict liability offence despite the amendments. The sentence of a fine has been abolished. There is now a minimum and maximum sentence of imprisonment ranging from 3 to 20 years. Further, in sentencing for the new offence of aggravated sedition, the judges are prevented from taking into account factors such as first-time offenders, young offenders, and the possibility of conditional discharge or binding over. The amendments therefore interfere with judicial discretion on sentencing and is a serious fetter on judicial functions in criminal matters. The amendments palpably constrict democratic space for frank, meaningful, and robust discourse. It has been said that the answer to noxious doctrine and fallacies is more speech and not enforced silence. We should therefore return to the original premise of repealing the Sedition Act 1948 and replacing it with national harmony laws. Recent and recurring fissures in our society, such as the Taman Medan church protest and the Lawyat Plaza incident, are examples of why the Sedition Act 1948 does not work. And it is national harmony laws that we should look to for help to strengthen national cohesion by protecting racial unity and nurturing religious harmony. I now wish to deal with the National Security Council Bill, which is possibly the most far-reaching law passed by Parliament in 2015. It creates a new statutory entity called the National Security Council and clothes it with enormous executive and emergency-like powers. The NSC is to be the central authority on matters concerning national security, which has not been defined. Critically, on the grounds of national security, the NSC can direct and control vital instrumentalities of government. The NSC Bill further provides that the Prime Minister may, on the advice of the NSC, declare any area in Malaysia, which could include the whole of Malaysia, as a security area on very broad and vague grounds. The initial period of the declaration is 6 months, and the Prime Minister may extend the period of declaration for an unlimited number of times, and therefore for an indeterminate duration of years. The wide executive powers exercisable by the NSC are not under the purview of Articles 149 or 150 of the Federal Constitution. The NSC operates above the Cabinet, and there are no checks and balances to these unbridled executive powers in the hands of the NSC. Thus, the NSC appears to be a law unto itself. Further, the emergency-like powers conferred on the NSC appear to subvert the constitutional role of the Yang di-Pertuan Agong in emergency matters, as provided for under Article 150 of the Federal Constitution. The NSC Bill enables the Prime Minister, either unilaterally or through the NSC, to exercise powers that are in effect emergency powers, but without need for a proclamation of emergency under Article 150. This usurps the powers vested in the Yang di-Pertuan Agong in Article 150. My Lord, apart from the concerns already expressed, there are a number of other troubling features that we see in both the Sedition Act and the NSC Bill. First, these laws were passed by Parliament in unseemly haste. There was a lack of transparency in the legislative agenda, an inadequate opportunity for mature consideration, proper reflection, and rigorous debate. This is always a recipe for abhorrent laws or laws that can be easily abused. Secondly, the manner in which the judiciary has been bypassed or sidelined in some of these laws is very worrying. This is perhaps due to the amendment in 1988 to Article 1211 of the Federal Constitution to delete the phrase judicial power. However, it is important to remind ourselves and our lawmakers that amendment in 1988 did not take away judicial power from the courts. My Lord, the Chief Judge of Sabah and Sarawak, correctly observed in the Kok Wah Kwan case, I do not think, as a result of the amendment, our courts have become servile agents of Federal Act of Parliament, and the courts are now only to perform mechanically any command or bidding of federal law. Thus, judicial power in our Constitution clearly remains where it has always been, namely with the judiciary. Thirdly, ouster clauses are antithetical to the rule of law as they seek to insulate executive action from judicial scrutiny. Under the separation of powers doctrine, the judiciary cannot be disembodied of its judicial power of determining the legality of executive action, particularly on matters concerning fundamental rights. Fourthly, in respect of the offence of sedition, the denial of the assessment of intention of mens rea, as well as the new minimum sentencing regime, displays a glaring lack of trust by our lawmakers in the judiciary to perform customary judicial functions. This is an incursion into the independence of the judiciary and lends further credence to the widely held view that the Sedition Act 1948 is a dressed-up legislative weapon to target critics of the government and dissidents in our society. Finally, the NSC Bill is a serious threat to our system of constitutional government. It vests and concentrates sweeping executive and emergency powers in the executive through the NSC. This upsets the delicate separation of powers in the Constitution between the executive, legislature and judiciary on the one hand and the constitutional monarchy on the other hand. We take the view that the NSC Bill is unconstitutional. The next area of challenge to the rule of law concerns One Malaysia Development Bharat, also known as 1MDB, the 1MDB imbroglio, and the vulnerability of critical institutions of state to interference and attacks. The allegations of financial irregularities involving 1MDB and the transfer of large funds in the Prime Minister's personal bank accounts thrust Malaysia into the international limelight last year for all the wrong reasons. Some of the investigations into these matters have been completed, while others are still ongoing. The Malaysian Bar therefore makes no comment as regards the culpability or otherwise of person or persons implicated by these allegations. However, the widespread reports of interference or obstruction of investigations into these allegations cannot be ignored. They have had the effect of undermining and weakening the institutions of state involved in the investigation. It is important that these disconcerting matters be acknowledged because they should not have happened and must never have ever happened in the national interest of Malaysia. The interference and obstruction of the investigations are well known and quite refutable. They included the abrupt removal of key persons leading or involved in the investigation, such as the former Attorney General, the disbanding of the multi-agency special task force that has been formed to investigate the allegations, the derailing and delaying of the inquiry by the Public Accounts Committee, PAC of Dewan Raya, into the 1MDB allegation, the arrest and detention of investigation of the arrest, detention or investigation of enforcement officers such as of the MACC, Bank Negara Malaysia, as well as the AGC, the raiding of the offices and homes of MACC personnel and the seizure of documents and computers, and the sudden transfer of 2 senior officers of the MACC to the Prime Minister's Department, which was subsequently rescinded. In all, these actions led to the irresistible public inference that investigations into 1MDB were being curtailed. It has further caused irreparable harm to the standing of the affected institutions in the public eye. The intimidation and harassment suffered by them are widely seen as a subversion of the administration of justice. The Malaysian Bar convened an extraordinary general meeting on the 12th of September 2015, where we condemned the interference and obstruction of the investigations and resolved that the government should establish a Royal Commission of Inquiry to inquire into the matter. We further resolved to take all steps deemed appropriate to uphold the rule of law, the Federal Constitution, and to protect the administration of justice, including to the Malaysian Bar, to commence legal action against parties responsible for the interference or obstruction. There have since been some developments in the investigations. However, the Malaysian Bar remains very concerned over the events that have transpired and the attacks that took place on the institutions, which may still persist. These institutions are undoubtedly critical to a functioning democracy and must not be undermined. We are also concerned about the rising public fear of a cover-up and the ultimate outcome of the investigation. We wish to express our undivided support for all institutions of state that exercise their mandate and duty in accordance with the law. We call upon all public institutions, in this case the AGC, PAC, BNM and MACC, to assert their independence, perform their role under the law in a transparent manner and not to bow to any form of pressure, intimidation or harassment. There is mounting public expectation that any wrongdoing should be exposed and those responsible be held accountable regardless of personalities. Anything less will precipitate a severe crisis of confidence in the administration of justice and the sanctity of the rule of law. In today's outlook of greater transparency, the judiciary cannot escape close scrutiny of its judgments. The right to comment on, praise, or criticize judgments is an indispensable part of the accountability process. It is often said, and it was said by Justice Bhagawati of the Indian Supreme Court, that justice is not a cloistered virtue and she must be allowed to suffer the criticism and respectful, though outspoken, comments of ordinary men and women. This is borne out by the high expectation among the public that the judiciary should truly make justice available to the people. Thus, judgments should not be immune from censure, but should be evaluated critically. However, the line between fair and measured criticism of judgments and the denigration of judges should not be transversed. Improper and intemperate criticism undermines the independence of the judiciary. My Lord, the late former Chief Justice, Tun Dr. Muhammad Sufyan said, Malaysia is fortunate in having a strong and independent, responsible and public-spirited bar, quick to rush to the defense of the independence of the judiciary. The statement was made in 1987, yet those words remain true today. The Malaysian Bar is committed to upholding and preserving the independence of the judiciary. In our 69 years of existence, we have repeatedly spoken out against unfair attacks on the judiciary, and we will continue to do so unwaveringly. In this light, we wish to raise two fundamental principles that should never be forgotten. First, it is a cardinal principle that courts are the guardians of constitutional rights. A vitally important function of the court is to interpret constitutional provisions conferring rights with the fullness needed to ensure the citizens have benefit of these constitutional guarantees are intended for. A former Chief Justice of the Hong Kong Court of Appeal, Hong Kong Court of Final Appeal, Andrew Lee, put it as follows: in a society governed by the rule of law, the courts must be vigilant in the protection of fundamental rights and must rigorously examine any restriction that may be placed on them. In short, fundamental rights must be generously interpreted and restrictions to them must be narrowly construed. Secondly, access to justice is a rule of law principle and must be seen as a fundamental right that cannot be abrogated. If a citizen is not able to approach the courts for legal redress, constitutional rights are illusory and the written constitution itself becomes a mere parchment piece. In this regard, Lord Wolfe, the former Master of Rolls, said, justice is valueless if those who believe their rights have been infringed are unable to access to a court, and if the result of the proceedings is not a just decision. Thus, access to justice requires our courts to jealously guard their jurisdiction and to be mindful that a legal wrong without a legal remedy would lead to a loss of confidence in the judiciary. The access to justice question is important to all citizens, most so for minorities. As Justice Michael Kirby of the High Court of Australia noted, the judiciary in a modern plural society must constantly strive to educate itself about the way laws fall unequally upon different groups in the community. They should attempt to protect minorities from inequality of treatment and unjust discrimination. They should thereby equalize the impact of law in a plural society so that the boast about equal justice under the law is not just empty rhetoric. The litmus test of a civilized society is the manner in which minorities and vulnerable groups are treated. As part of the citizenry, they look to the courts for protection of their constitutional rights. They have no other avenue for justice. And as the United States Justice Leonard Hand said, if we are to keep our democracy, there must be one commandment: thou shalt not ration justice. My Lord, the past year saw the appointment of Tan Sri Dato Sri Haji Muhammad Apandi bin Haji Ali as the Attorney General of Malaysia with effect from 28 July 2015. He was a member of the Malaysian Bar for 22 years and served as a member of the Bar Council for 8 terms, including as an office bearer for 2 terms. As with all members of the Malaysian Bar who have served on the Bar Council, we are thankful for his services. Tan Sri Apandi has now greater responsibilities, which we trust he will discharge in a manner befitting the high calling in the office of the Attorney General. We will be meeting Tan Sri Apandi formally for the first time next week to discuss issues concerning professional practice and the administration of justice, and we hope to have a constructive meeting. We have and always have had a collegial working relationship with the AGC on a variety of matters concerning the legal profession. We are appreciative of the continuing efforts of the members of the AGC in the liberalisation exercise. More recently, we have been working with them on the amendments to the Legal Profession Act 1976 to introduce limited liability partnership as a new structure of legal practice. We are thankful for their valuable input, and with their cooperation, we are hoping to have this amendment in Parliament this year. The Malaysian Bar looks forward to another productive year of cooperation and collaboration with the AGC. We take this opportunity also to record our appreciation to Tan Sri Abdul Ghani Patel, the former Attorney General, with whom we enjoyed a constructive working relationship on a variety of matters such as YBGK, the liberalisation of the Malaysian legal profession, and the Common Bar Course. We wish Tan Sri Abdul Ghani all the best in his future endeavours. Now, in conclusion, it has been observed that legal practice has an important context not shared by other occupations. Lawyers have a special position in society not because they are loved or because they are particularly admirable people, but because they are responsible for the rule of law. The Malaysian Bar will continue to stand in the gap to uphold the rule of law and perform our statutory duties as mandated by Section 42(1) of the Legal Profession Act 1976. We look forward to the continued working relationship with the judiciary and the AGC as partners in the administration of justice, to preserve and protect the rule of law and to uphold the supremacy of the current constitution. I wish to also here express the appreciation of the Malaysian Bar to the Minister in the Prime Minister's Office, Yang Berhormat Puan Hajar Nancy Shukri, for continuing to keep the door open to the Malaysian Bar. My Lord. Permit me now to conclude with the customary pantun. Buat cempedak di luar kebun, ambil galak tolong dijulurkan. Presiden Bar ingin berpantun, pantun salah tolong betulkan. Ditanam keladi, semoganya subur, keladi tanam di pekan segaman. Perlembagaan kita harus didukung, undang-undang adil, wajar didaulat. Bentan keladi diberi nama, namanya masyhur di Nusantara. Hak rakyat sekiranya dinoda, Bar Malaysia pastinya membela. Jika mengusap ayam serama, jangan sampai bulunya keluar. Keadilan tidak kenal warna, adil itu tuntutan semua. Belayalah ke Pulau Labuan untuk mencari intan permata. Negara kita penuh cabaran, mari pikul amanah bersama. On behalf of the Malaysian Bar, the Advocate Association of Sarawak, and the Sabah Law Association, I wish the members of the judiciary, the Attorney General's chambers, as well as the members of the Bar, a healthy, fruitful, successful, and peaceful year.